Chapter 42, Equitable Estates and Interests under the Contract of Sale and Purchase of Land. Analysis. Section 838. The Equitable Conversion. Lord Eldon, in Seaton v. Slade, states the result of the contract to purchase land thus: the effect of a contract to purchase is very different at law and in equity. At law the estate remains that of the vendor, and the money that of the vendee. It is not so here. The estate from the sealing of the contract is the real property of the vendee. It descends to his heirs. It is divisible by his will, and the question, whose it is not to be discussed merely between the vendor and vendee, but may be to be discussed between the representatives of the vendee. Section 839. Rights of inheritance from parties to the contract. General principles. The rights of the heir and the representatives of the vendor and vendee, on the decease of either before title has passed under a valid contract to convey lands, follow directly from the fundamental principle of equity, that in equity, upon an agreement for the sale of lands, the contract is regarded for most purposes, as if already specifically executed. The purchaser becomes the equitable owner of the lands, and the vendor of the purchase money. In working out the testamentary rights of the heir and the representatives as to land under the contract for sale, equity considers these rights as if the title to the land had actually passed before the death of the vendor or the vendee. Although the purchase money is unpaid, if the contract is valid and binding, it has this remarkable effect, that it converts the estate, so to say, in equity. It makes the purchase money a part of the personal estate of the vendor, and it makes the land a part of the real estate of the vendee. Section 840. Heir or devisee of vendee. Thus, where the vendee dies, having a contract for lands, but the conveyance has not yet been made to him, the vendee's interest in the lands shall be considered as real estate and descend to his heir, or he may devise them by will, and his representatives shall pay the purchase money out of the assets. The heir or devisee of the vendee in equity can compel the executor or administrator to pay the unpaid purchase money out of the personalty, for equity regards the transaction as completed, and a conversion to have been made of that much of the vendee's personalty from the date of the contract. Section 841. Vendor's representatives. In the case of the vendor's death, where he is under contract to sell lands, his heir receives the title in trust for the vendee, and must convey upon payment of the purchase money. But the purchase money goes not to the heir, but to the personal representative of the vendor, for the vendor's interest had been converted by the contract from realty into personalty. The executor of the vendor can bring suit for specific performance of the contract, and compel the purchaser to pay the purchase price, and joining the heir, compel him to convey the land to the purchaser, the executor holding the proceeds as personalty for those entitled. Section 842. Rights of inheritance where the contract is never performed. If the contract cannot be carried out after the death of either of the parties, the rights of the heir or next of kin in the testator's interest are treated precisely as if the contract had been carried out, if the contract was valid and enforceable by the testator at his death. Thus, where after the vendee's death, the contract was rescinded, the administrator was compelled to pay to the vendee's heir an amount from the personalty equivalent to the price of the land. Where a purchaser loses his right to specific performance by his lackeys, the interest of the next of kin of the deceased vendor is not affected. Although the land does not pass to the vendee, yet the estate will belong to the next of kin of the vendor and not the heir, who held the title in trust for the vendee. This disposition arises from the principle that a valid contract works an equitable conversion of the land into personalty from the time when it is made. And on the principle of equitable conversion, the purchase money became a part of the vendor's personal estate, and as such was distributable to his widow and next of kin. Section 843. Same when the equitable conversion is not made. But the contract must be valid and enforceable at the time of the death of the testator in order that the equitable character of the estate shall prevail over the legal, i.e., that there shall be in equity a conversion, as, of the vendor's interest in the land into personalty. As an illustration of this principle, the question of title is very important. Not only must there be a good contract from the legal point of view of consideration, but if the vendor could not make a good title, equity would not decree specific performance, and there is no conversion, then the vendor's interest at his death is land, and the vendee's interest is personalty, notwithstanding the contract. Lord Hardwicke stated the rule: when an ancestor, after the making of a will, agrees for the purchase of particular lands, the heir at law would have a right to them, provided a good title can be made out. Otherwise, if it cannot, and the heir of the vendee cannot have the money laid out in other lands, the interest is then only personalty. But the fact of the purchaser being able to pay or not able to pay is immaterial. If there is a valid contract, the conversion is effected. Section 844. On death of vendor in possession, the rents go to the heir. Where the vendor is himself in receipt of the rents at the time of his death, as is usually the case up to the time for the possession to be changed from the vendor to the vendee, not the next of kin, but the heir, who takes the legal title, to hold until the purchase money shall be paid, is entitled to the rents up to the time the vendee could claim them, in lieu of interest money paid. It is true that equity considers the equitable conversion to have been made from the date of the contract, so that the next of kin can demand the specific performance of the contract, and have the purchase money, but nevertheless equity having permitted the vendor himself to retain the beneficial interest in the land, the rents, up to the change of possession, the heir is entitled to that same beneficial interest as realty. Section 845. Effect of unperformed conditions. Enforceability of the contract at the time of death of one of the parties refers to the validity of the contract and not to events in the nature of conditions which may not have been performed because such performance was not due at the time of the death of testator. It is sufficient if these conditions are performed by his representatives. Provisions of the nature of conditions in contracts of sale do not alter the rule that the contract of sale is an equitable conversion of the realty into personalty. Section 846. Option to purchase, exercised after death of vendor. When a binding option for the purchase of land is not exercised until after the death of the vendor, it is the rule, often criticized for its harshness, that the conversion then relates back, as between the heir and personal representative of the vendor, to the date of the contract by which the option was given. The personal representative of the vendor, therefore, is entitled to the purchase money, but the heir is allowed to receive and retain the rents up to the time when the option was exercised. Section 847. Devise of lands contracted for. Lands contracted for pass by the devise of the vendee, and his executor must pay the purchase price out of the personalty. Even though the devise is general, as, all my lands, it passes the equitable title of lands contracted for by the vendee. The devisee can bring suit to compel specific performance of the contract. A devise by the vendor of all real estate which may be vested in me as trustee passes the vendor's title in lands contracted to be sold, the devisee in trust, and not the heir, taking the title to hold for the purchaser. Section 848. Contract to sell revokes will pro tanto. Where a testator, subsequent to making a will devising certain lands, enters into a valid contract to sell the lands, the contract is usually said to revoke the clause of the will relating to the same land. Another view is that the contract takes the land out from under the operation of the will, and hence there is nothing for the will to act upon. The contract to sell operates an equitable conversion of the land, and the prospective devisee can receive it then only in trust to convey, as from that time the land is in equity personalty of the vendor. The conversion by the contract had the effect of taking the land from under the operation of the first clause of her will, and giving the proceeds of it to her residuary legatees and devisees as a part of her personal estate. Though the contract to sell is rescinded, the clause of devise in the will is not allowed to operate on the land. Chancellor Kent states the doctrine of revocation of a testamentary clause by contract to sell to be in equity like a legal conveyance in law. There a subsequent reconveyance does not restore the devise. Once revoked by the contract, the devise is gone forever, unless the will is republished. As the executor's power depends upon the establishment of the contract as against the devisees under the clause of the will, the devisees should be made parties to the bill. Section 849. Dower interests under the contract. A notable exception to the identity of equitable and legal estates formerly existed, in that a widow was not dowable in a trust estate. But this anomaly has now been removed by legislation in England and the United States generally wherever dower interests are recognized, and the widow of the vendee is entitled to the dower interest in the lands of which her husband is beneficially seized by his contract. The courts have often had to determine whether the statute giving the widow dower in equitable estates extended to those arising from a contract for the sale of land, but there has been no hesitation in finding that they were so included. Following the general rule, in order that the widow may have dower under the statute, the contract for the lands must have been enforceable by the vendee at his death, or of such nature that it could be completed after his death. In a number of states, alienation by the vendee of his equitable interest in the lands contracted for, but not conveyed, defeats the widow's right to dower. He must be beneficially seized at his death for her dower right to attach. If the personalty of the vendee's estate, the primary fund for the purchase of the land contracted for, is insufficient to complete the purchase, in most jurisdictions it is held that the widow must contribute her proportion with the heirs towards the purchase money. Where the contract for the sale of the lands is made prior to the marriage of the vendor, equity regards him as holding his legal title and trust for the vendee, and by the usual rule that no dower interest attaches to a trust estate, the widow of the vendor has no dower in the lands contracted to be sold before her marriage. But if the contract fails of completion because of defect of title, the vendor's widow has her dower. No equitable conversion had taken place. Section 850. Assignees and subsequent purchasers. Right of the assignee of the vendee. The assignee of the vendee's contract is regarded in equity as stepping into his shoes, succeeding to his rights to the land, which is regarded as a trustee's or mortgage security. The assignee of a contract, although it is a chosen action, after a demand of performance, and refusal on the part of the obligor, may in equity maintain suit in his own name for specific performance. This right of the assignee of a vendee to compel specific performance of the contract for conveyance is everywhere recognized. The assignee of the vendee's option to purchase may enforce the option in equity. It is a right growing out of the contract for the option, and equity completes the right. The vendor's defense of insolvency of the vendee in a contract for lease does not avail him against the vendee's assignee, who is solvent. The latter is given specific performance against the vendor, although the assignor could not obtain it. But to obtain specific performance, the assignee must respond to all obligations for which the vendor holds the land in the way of a security. Thus the unpaid notes of the vendee given to the vendor for the land must be paid by the assignee of the vendee before he can obtain specific performance of the contract. The assignee can enforce the rights of the assignor under the contract, but he can have no greater rights than they, the assignors, had, and he is bound to do all which they would be required in equity and good conscience to perform before obtaining a conveyance. The assignee of the vendee is not entitled to specific performance while his obligation to his assignor remains unsettled, for the assignor must be allowed to receive the conveyance from the vendor to hold as security against the assignee until the latter has satisfied his obligation. Thus, where a vendor conveyed to the vendee's assignee before the latter had paid the vendee, in fact before the assignee's obligation had matured, the court decreed that the assignee should convey to his assignor. Section 851. Assignee of vendee not subject to specific performance. Although the assignee of the vendee has all the right of the vendee in the contract, he is not subject to the obligations of the contract, except upon his option to enforce specific performance. Thus he can proceed in equity against the vendor to secure land, but the vendor cannot proceed against him, the assignee, to compel him to take the land. The remedy of the vendor is against the buyer, and, by way of enforcing the vendor's lien, against the land. Section 852. Grantee of vendor is subject to specific performance. Just the reverse is true of the grantee of the vendor. He is subject to specific performance by the vendee or the vendee's assignee, where he has notice of the prior contract, or has given no value for his title. It is everywhere settled that if the grantee takes the title from vendor without knowledge of the prior contract, giving value therefore, he can retain it, and the vendee has no remedy against him. Section 853. The equitable ground for rights against the grantee and in favor of the assignee of the vendee. This power of the buyer or his assignee to enforce specific performance against the grantee with notice or without value given, is due to the view in equity that a trust attaches to the land by the contract, and whoever takes the land with notice or without paying value, holds merely the legal title in trust for the buyer or his assignee. It is to be added that the title is held not as a dry trust but as a security title, unless the entire consideration has been paid. Neither the vendor nor his assignee have any right of specific performance against the vendee's assignee. However, since there is no trust trees held by the assignee, the buyer holds no particular fund which is turned over to his assignee. His obligation is only to pay out of his general substance. His assignee's only obligation is personal to him, the buyer, and therefore cannot be reached by the seller. The only right of the vendor or his assignee against the vendee's assignee, if he have the land without having paid the purchase price when due, is to have the land sold to satisfy the debt, as on the foreclosure of a mortgage. Section 854. Assignment of the purchase money notes transfers the security. The vendor's interest when the purchase money is unpaid in part or whole has frequently been said to be like the interest of a mortgagee. Following out the analogy, if an assignment is made of the purchase money notes, this operates in equity as a transfer of the security. The vendor, though continuing to hold the legal title, holds it first in trust for the assignee of the notes as security for the purchase money notes, and only after the satisfaction of that security, on a resulting trust for the vendee, the assignee of the notes may file a bill in equity to subject the estate to the payment of his debt, although there has been no assignment of the estate to him. Section 855. Vendor's assignee in bankruptcy subject to specific performance. Where the vendor is bankrupt, if all the purchase money has been paid, specific performance can be enforced against him, as he is a mere trustee, holding nothing but the bare legal title. But where the purchase money has not all been paid, the vendor's assignee in bankruptcy holds the interest the vendor had in the lien on the land for the purchase money, but specific performance can be had against the assignee in bankruptcy by joining him with the vendor. As the court in Swepson v. Rousseau puts it, the vendor was not a mere naked trustee, but to secure residue of the purchase money, he had a lien on the land, which was an assignable interest upon his bankruptcy and necessarily passed to his assignee. Section 856. Vendee's assignee in bankruptcy not subject to specific performance, but the assignee of the vendee in bankruptcy, on the contrary, is not subject to specific performance of the contract. There is no reason why the vendor as a creditor should be preferred to other creditors. There is no trust rees to be delivered, as in the case of the vendor's assignee in bankruptcy. The contract, however, is not discharged by the vendee's bankruptcy, and his assignees may at their option have specific performance of the contract against the vendor. Section 857. Waste by vendee. By vendor, the vendor's only interest in the use of the land he has contracted to sell is to have his security unimpaired so that it may satisfy the unpaid purchase money. The vendee in possession is entitled to make any use of the property so long as he does not materially affect its value as security for the purchase money. In order that the vendor may have an injunction to prevent waste, he must show that the vendee is lessening the value of the land so as to impair his security, and thus to injure his property, the security. The analogy to the mortgage is close. A mortgagee cannot maintain an action to restrain waste without showing that his security will be impaired. Where the buildings annexed by the vendee subsequently to his taking possession can be removed by him is a point in conflict among the cases. The California courts hold that as the original security is not impaired by their removal, the vendee can remove them. In Illinois it is held that the improvements, becoming permanently annexed to the land, cannot be removed. Since in equity the real interest in the property is in the vendee, the vendor, though holding possession of the land, must not make other than ordinary use of the land, and he will be enjoined from committing waste, such as cutting trees, quarrying, or removing soil. Section 858. Vendor may be liable as trustee for deterioration. This rule is well stated by Lord Coleridge. During the interval prior to completion the vendor in possession is a trustee for the purchaser and as such has duties to perform towards him, not exactly the same as in the case of other trustees, but certain duties, one of which is to use reasonable care to preserve the property in a reasonable state of preservation, and so far as may be, as it was when the contract was made, or as Lord K expresses it, to take reasonable care that the property is not deteriorated in the interval before completion. Section 859. Loss by fire or other accident, usually falls on vendee, upon whom should the loss, as where the buildings are destroyed by fire, occurring between the date of the contract and the conveyance, fall following out the rule of equity that as soon as the contract is finally concluded, although it is wholly executory in form, there results by its operation an equitable conversion of the land and the purchase money, and the purchaser then becomes the equitable owner of the land. The conclusion can hardly be escaped that the loss should fall on the vendee. Of course the risk of loss by special stipulation can be placed on either party, as where the vendor by his contract was to complete a certain building before vendee's taking possession, the inference is that loss would fall on the vendor. Equity, from the moment the contract is binding, gives the vendee the entire benefit of the rise in value of the land and of all subsequent improvements, and any other advantage that may accrue to the estate. If the vendee is owner in equity so as to receive all increment, he should be considered owner so as to accept the burden of any loss not due to the vendor's fault. This was the view taken by Lord Eldon in Payne v. Miller, which established the doctrine in England, as a general rule of equity, that all loss by fire or other accident shall fall on the vendee rather than on the vendor, after the vendor is in position to make a good title, or the vendee has accepted the title, in other words, as soon as the contract is capable of specific performance by the vendor. Section 860. Vendee generally entitled to the insurance money. On principle it would seem clear that in all jurisdictions throwing the loss by fire on the vendee, the insurance money should go to the vendor in trust for the vendee, to be paid when the vendee should satisfy the security lien of the vendor. Such is the view of the American courts which have passed upon the question, but in England, in a decision very difficult to reconcile with the general equity doctrine of Payne v. Miller, it was declared by a divided court that the vendee is not entitled to the insurance money, and by a later decision that the vendor himself must refund the money to the insurance company if paid to him. Section 861. Loss by occurrence of contingency on vendee. By the same reasoning that casts the loss by fire on the vendee, is the loss by the happening of a contingency put upon the vendee. Thus, in White v. Not, T superscripta where one contracted for an estate for 2 lives, and one of the lives dropped prior to conveyance of the estate, the buyer was compelled to accept conveyance and bear the loss. For in equity the estate is as conveyed from the time of the articles sealed. The Lord Keeper doubted, however, had all the lives dropped, whether the vendee should have the loss on him, as, no estate being left, there could be no conveyance. But this dictum was properly overthrown in a later case where, the only life having dropped, the buyer was nevertheless compelled to pay the purchase price. Similarly, where the agreement is for the purchase of an annuity for the vendee's life, though the vendee die before the first sum be due, and the vendor will never have any annuity to pay, yet must the estate of the vendee pay the purchase price. Section 862. Foreclosure of vendee's equity of specific performance. The analogy of the relation arising from the contract of sale and the mortgage relation serves equity again in tracing the right of the vendor to be freed from the vendee's continuing right of specific performance where the vendee himself will not pay the purchase money. The vendee, who corresponds to the mortgagor, failing to pay the purchase money, still has his equity of redemption. The vendor has neither his money nor the land, for he has hanging over him the vendee's right in equity to have the land, and has no power over the land other than that of a mortgagee, i.e., to hold it as security. But to do justice to the vendor, where the vendee fails to pay the purchase money, equity allows a foreclosure of the vendee's right to have specific performance, analogous to the foreclosure of the mortgagor's equity of redemption. By the decree, the vendee is ordered within a reasonable fixed time, to pay the purchase money, or to be forever foreclosed of his equity in the contract. Section 863. Sale of the property, in lieu of strict foreclosure. Most jurisdictions in the United States, however, do not decree a strict foreclosure, but, instead, decree that if the purchase money is not paid within a time set by the court, the property shall be sold, and the vendor's interest satisfied out of the proceeds. This may be treated as a forced sale of the vendee's equitable interest to satisfy the unpaid purchase money, Any balance accruing to the vendee,